due process is healthy and all citizens are entitled to access to the courts, and ultimately in due course the courts will determine those applications that come before them. In point of fact, the particular application that was before the court that was ruled on this morning under section 14 subsection 4 is an important application and an important section. Section 14 subsection 4 says, where in any proceedings in any court other than the High Court or the Court of Appeal. So we pause there and we recall that the proceedings that were ruled on this morning were in the Magistrate's Court. So where in any proceedings in any court other than the High Court or the Court of Appeal, any question arises as to the contravention of any of the provisions of this chapter, the person presiding in that court, in this case the Chief Magistrate, may and shall, if any party to the proceeding so requests, refer the question to the High Court, unless in his opinion the raising of the question is merely frivolous or vexatious. So that is the corridor of opportunity which the Constitution allows to a person in the circumstances of Mr. Jack Warner to get access to due process, even after an applicant such as Mr. Warner has been before the High Court, that was before Mr. Justice James Abood, before the Court of Appeal, and before the Privy Council. In the High Court, in the Court of Appeal, and in the Privy Council, Mr. Warner lost on every occasion in his attempts to stop his extradition from Trinidad and Tobago to the United States of America at the request of the United States of America for criminal offenses that the United States of America, as the requesting state, is of the view that Mr. Warner has committed in that country, the requesting state. The history of the matter is important in terms of just a brief timeline, so that Mr. Warner's extradition was first requested on the 27th of May 2015. And a very competent team of attorneys were retained at that time by Mr. Garvin Nicholas, then the Attorney General. That team of attorneys were Mr. James Lewis, then King's Counsel, Mr. Israel Khan, Ms. Pamela Elder, Mr. Jack Deo Singh, Mr. Gerald Ramdeen, Mr. Wayne Sturge, instructed by Mr. Brent Holpike. And that team was appointed by the then Attorney General, assisted by Mr. Netram Cowlisser from the Central Authority Unit of the Office of the Attorney General, which deals with extradition matters. It's interesting that as the matter progressed, the different governments which have had to deal with this matter, so in September 2015, the government changed and a new government took office, and these which continued to be retained by the new government included Mr. James Lewis, King's Counsel, Ms. Pamela Elder, and added to that team were Mr. Das Mendez, Mr. Rishi Das appears for Mr. Warner, Mr. Netram Cowlisser, and right up to today, the team representing the United States of America and Republic of Trinidad and Tobago continue to consist of very competent attorneys who have argued this case on behalf of the state of Trinidad and Tobago and the Republic and the United States of America from 2015. Ms. Pamela Elder, Mr. Netram Cowlisser recently brought in. I make that point to demonstrate the due process point, that there has been a significant concerted attempt to ensure that the state was always represented by able counsel, has also been represented by able counsel, led throughout and from inception by Mr. Fayed Hussain, senior counsel, and counsel, now senior counsel, Mr. Rishi Das, and others. The members of the media will recall that there was a judgment of the Privy Council which was given on the 17th of November. I think earlier I said the 27th, on the 7th of November 2022. And a number of arguments were raised by Mr. Warner in a judicial review application which started before Justice Abood, went to the Court of Appeal, and finally dealt with by the Privy Council. And two of the arguments which were raised by Mr. Warner before the Privy Council were the argument, what is known as the specialty argument, which is a particular process under extradition proceedings, which is to say that the Attorney General of the state from whom extradition is requested. There are two parties. There's the requesting state and the requested state. The Attorney General will receive a request from the requesting state, in this case the United States of America, and sign off on a certificate and authorize the authority to proceed for the extradition proceedings to continue. Before the Privy Council, through from Justice Abood right up to the Privy Council, was that the specialty argument had been violated in that there was no consistency between the offenses for which the United States of America wished to extradite Mr. Warner, consistent with the laws of Trinidad because of different arrangements between the treaty to which the United States 17th of November and the Privy Council ruled that the extradition on that ground could proceed. Another argument which Mr. Warner had raised before Mr. Justice Abood failed, before the Court of Appeal failed, before the Privy Council, and failed, was that he had not been given rights of fair procedure. And again, those arguments failed. And one, just by way of reference, you base those arguments and the reasoning of the Privy Council on the specialty argument, paragraphs 65 to 82 of the Privy Council decision, and paragraphs 83 to 95 on the unfairness of process decision made by the Privy Council, dated the 17th of November 2022. Subsequent to the decision of the Privy Council, Mr. Warner then proceeded to file, as I have said, his application, this is to say, application pursuant to section 14, subsection 4 of the Constitution of the Republic of Trinidad and Tobago on the 3rd of March, and he listed a number of questions which had to do with the fact that his rights under the Constitution have been violated by the continued efforts of the United States of America as the requesting state to have the government of Trinidad and Tobago extradite him to the United States of America to stand trial there. That matter, that application, was supported by an affidavit of Mr. Warner. There was no other evidence on that affidavit, on that application. No other parties filed any evidence, and really the question as set out in section 14.4, which I have read, was whether Mr. Warner had raised issues that required the High Court to address a violation of his constitutional rights in accordance with due process. And the only basis on which the magistrate, the chief magistrate, could have declined to accede to that application of Mr. Warner was if she found that the arguments raised by Mr. Warner were frivolous and vexatious. This morning, the Chief Magistrate ruled that the questions were not frivolous and vexatious in respect on the specialty argument on procedural unfairness, and therefore she has referred those questions to the High Court for the High Court to determine the constitutionality of the request of the United States of America of Trinidad and Tobago to extradite Mr. Warner to the United States to stand trial on a number of serious criminal offenses. The Chief Magistrate went on to make findings of fact which disturbed me, and I say that with all due respect, because all that was before her was the affidavit of Mr. Warner, and no evidence from any other parties and no cross-examination of anybody at all. And I have been in touch since the decision was handed down this morning at 10 o'clock approximately. I have been in touch with the legal team representing the Attorney General and the United States of America. I have spoken with Mrs. Elder, Senior Counsel. I've not spoken with Mr. James Lewis because I was in the Senate when I got word of the decision and when I decided to call this media conference, and I did not think at this time of the evening I should disturb Mr. James Lewis, King's Counsel, who resides in the United Kingdom. But I have spoken with Ms. Elder, and she has assured me that she will be meeting with the team to review with some concern the decision of the Chief Magistrate insofar as it would appear that there is, and these are my words, I'm not attributing these to Mrs. Elder, so let me be very clear, that there is no justification for the findings of fact which the Chief Magistrate permitted to arrive at. We will be meeting with the legal team led by Mr. Lewis and Mrs. Elder after they have met in order to take their advice as to the steps that the government must take to continue to insist on all persons coming before the courts so that justice must be done, to continue to due process and in due course to get the full determination of the High Court, the Supreme Court of Trinidad and Tobago, on Mr. Warner's several applications. Part of the nature of due process is that it is not always as speedy as we would like it to be, as expeditious as we would like it to be, and I think that this case is one such case in point, and it is clear that there will be still some passage of time before the citizenry is going to be able to repose with confidence on the final decision to be made in respect of the request of the United States of America to have Mr. Jack Warner extradited to that country to stand trial for serious criminal offenses. So I've called this media conference not to shed as much light as I suspect you all would hope that I could shed, because I am going to be awaiting the advice of the team of attorneys retained by the state of Trinidad and Tobago to understand better the decision that has been made in this particular matter by the Chief Magistrate this morning. And I reiterate the fact that I am concerned that findings of fact appear to have been made which are not justified on the evidence that I have seen and the test of cross-examination which one would expect of witnesses whose credibility has been tested. There was only one affidavit before the court, the affidavit of the applicant, and the questions which have been referred to the High Court are the questions asked by Mr. Warner of the magistrate to be referred to the High Court. So we are in a condition known as sub se, that is to say, the High Court has now been asked on a referral by Mr. Warner to determine certain questions. I would expect in due course there will be a scheduled hearing of the High Court, and I hope by that time to have received sufficient advice from the team advising the Attorney General and the team advising the requesting state, the United States of America, so as to better advise myself on the options available to the Office of the Attorney General in this matter. So that's basically as much as I can tell you all at this point. I am going to open the floor really just to questions, but let me preface it by saying immediately that I do not consider myself at liberty to answer many questions for the reason that, one, I have not yet the advice of the legal team advising the Attorney General. The decision was given this morning at 10 a.m. That team has not yet met, but I thought it appropriate that I should call the citizenry and the media today so as to express the government's concern at the decision and to advise that we will continue to ensure that justice is done. The second reason why I will find it difficult to answer any questions is, of course, the fact that this matter is now alive as a matter of sub judice, and I, as the Attorney General, who may still be required to sign a certificate of authority to proceed under the extradition proceedings, I must be very careful to afford Mr. Warner the right to a fair trial and not be seen, heard, or otherwise understood to say anything that could be said to amount to a violation of Mr. Warner's rights to a fair trial. So with that said, ladies and gentlemen, Mr. Jensen-Levin, good afternoon. Other members of the media, happy to see you all present, and I would hope that I do not disappoint you all too grievously by being unable to take the very many questions that I know you have been willing to throw.
Good afternoon, sir. Jensen-Levin, Newsday. Hope all is well with you, sir. I just have 3 questions on this issue, not many at all. If memory serves me correctly, findings of fact is a matter reserved for the High Court, yes?
Well, do you mind if I ask you to state the 3 questions and then we'll take them one at a time, if you don't mind?
So that's one. The second one is, how is it, or why was it that the affidavit filed by Mr. Warner was not responded to in any form by the state? Because you said he did file this affidavit and it went unchallenged, my words, not yours. And the last question from me is, this matter, as well as the airport inquiry matter, has been going on for quite a number of years. The recent one finished, when that was, a couple months ago? Those 2 cases, has it hampered relationship between Trinidad and Tobago and the United States?
Thank you, Mr. Levin. In response to your first question, whether findings of fact are reserved for the High Court, no, that is not correct. In our judicial system, we have different courts as fact finders. We have the magistrates' courts, now known as the district courts under the legislation that exists, and the High Court. And both at the magistrates' court level and at the High Court level, the judicial officers who man or woman those courts make findings of fact as they are entitled to do in accordance with due process. In answer to your second question, how is it that the affidavit of Mr. Warner was not answered? I have not yet spoken with the team that represented the state and took the decisions on the case management. In due course, I may be able to answer that question. For the time being, I can't. In respect of the third question, to the extent that you asked me to address a question involving Mr. I have recused myself from the airport matter, and therefore I wouldn't even be able to speak to it, even if it is to another matter. I'm not getting involved in the airport matter or any questions potential to the airport matter. Thank you.
Hi, Mr. AG. Kijan Haynes here. Now, you will appreciate that not everybody may have been able to digest the findings of the court this morning. It's barely been published online or anywhere. So if you can, for people who are listening live on this, I know the government took some flack for or your office, I guess, would have taken some flack for not filing procedural. Can you just explain to the public very quickly what were some of the complaints raised by the Chief Magistrate, and going forward, how you plan to hopefully hope that it doesn't happen again?
So if I may attempt to address that question, Mr. Kijan Haynes, by referring to the first comment that you made, which is that not everyone has been able to digest what transpired this morning. As I said, I was in the Senate. I too have not been able to digest everything that has been said, and it would be inappropriate for me at this stage to attempt to comment on the decision and the details of the decision, including things that you are telling me, which I'm hearing for the first time about flack and findings of the Chief Magistrate, until I have spoken with the legal team who represented the state before the Chief Magistrate. So I'm afraid I can't assist you as much as I'd like to in answering that question.
But are you seeing this as a problem in your office that needs to be addressed, or you're still waiting until you get more information before
What is the this to which you refer that's a problem in my office? Can you help me understand that question?
If there were issues in terms of procedural, that's what I said. I'm still trying to read as we go along here. So are there issues in your office that were raised in the judgment that need to be addressed, is what I'm trying to get at.
Well, to address the concern that you expressed, whether this is a problem in my office, the reality is, Mr. Kijan Haynes, I have not completed my review of what the decision amounts to in detail. I have not had an opportunity to confer with the lawyers representing and advising the Attorney General, and therefore it would be inappropriate, and in point of fact, it would be less than prudent for me to appear to comment. So I don't see that as a problem. I see that as me adopting a prudent, cautious, well-advised course, not to shoot from the hip.
AG, I know you said you don't have all the facts at this time, but my colleague who was at the court says that there was some agreement by the central authority that was raised within the matter that Mr. Jack Warner spoke of, and it seems that that document, that agreement, was not found, and the Chief Magistrate would have criticized his state for not producing said agreement, said document. Can you speak to that?
I would rather not speak to that, in that I'm not sure what it is your colleague is reporting to you was done or said by the Chief Magistrate. All that I will say is that from the little that I have been told, it would appear that the Chief Magistrate allowed herself to make findings of fact which are of concern to me, and it is for that reason that I have asked to meet with the Pamela Elder team at the earliest opportunity, excuse me, so that I may be better apprised as to what took place today.
From my understanding is that for all extradition matters, there is some sort of agreement signed by the state that says any charges that are to be brought against this person who is extradited must be detailed, and there are no other charges that can be brought once the person is extradited. What I'm understanding is that that agreement can't be found.
Well, I'm not aware of the details that you're going into. I can say that in extradition, and I will take my leave after I answer this question, Mr. Levend, if you don't mind.
I have a few more.
What I can say is that in extradition proceedings, there is a certificate which is signed off by the Attorney General, and under the rule of specialty, what the rule of specialty says is that the basis on which the Attorney General will sign off for a person to be extradited must be for offenses which are common to both jurisdictions, so that the person extradited does not face jeopardy to be prosecuted for additional offenses that the state sending the person across did not have on its law books. That's the gravamen of the law of specialty, to ensure that there is comity between the laws under which the accused person will be tried. But I'm not going to go into, I don't want to appear to be speculating on what occurred. And in due course, I am likely to issue a statement. So, ladies and gentlemen, thank you very much. No, the one I just answered. Thank you very much.
This is TTT. Live for local.
A whale of an escape. Hey, Dad. What are you doing? Oh.
All done. Then.